million at the hands of an investment advisor and the affiliated brokerage, and then got hit with a $300,000 attorney's fees judgment for the arbitration. I would like to make 3 points in the argument today. Number one, the arbitration should have been vacated. The award was required to be vacated under section 682.13, which says the circuit court shall vacate an award when the arbitrators refused to hear relevant material evidence or otherwise conducted the proceedings in a way that would prejudice the rights of any party under section 682.06. And that section 682.06 gives some due process rights to present evidence, to cross-examine witnesses, to be heard. And point number two, the attorney's fees should not have been awarded for several reasons. A couple are that it was not clear that any Chapter 517 claim was actually decided and ruled upon as the basis for the arbitration award.
On that point, if you would respond, paragraph number 3 of the arbitrator's award says, any and all relief not specifically addressed herein is denied. Would that or would that not encompass the 517 claim?
I don't think so, Your Honor. I've seen cases where, such as Applebaum, the Fayetteville, where that language appears to be included in these awards routinely as a boilerplate language, and it didn't necessarily get inserted into this award on purpose as an indication that the Chapter 517 claim was truly reached on the merits. And furthermore, there is evidence in the record where even the brokerage stated in closing argument that to the extent that the panel may proceed to rule upon this issue, they request that it would be specified in the order. But it was never specified in the award. The only two claims that were specified were the same two that were presented in the original statement of claim, and that is common law claims for breach of contract and failure to supervise. And the third point for today is that the fees award is erroneous because it's not founded on substantial evidence where the appellant's attorneys were prevented from obtaining the information they needed to find out how much of that amount was reasonably attributable to a Chapter 517 claim, assuming that any 517 claim actually would lie. And first, let me address the issue of the lack of evidence regarding the duty to supervise the registered investment advisor. That advisor was affiliated with the brokerage, and the brokerage vice president admitted that the registered investment advisor division is a business line of the brokerage. FINRA rules state that every business line must be guided by procedures and manuals for supervision. So whether or not this advisor was an associated person, which was an issue in the arbitration, still the expert testimony revealed that there had to be some kind of procedures and manuals in writing. And the brokerage was ordered twice. They were compelled and yet ignored these orders to compel the production of such manuals. And without those manuals, our clients were severely prejudiced because it left the arbitrators in the dark to decide whether or not this investment advisor had to be supervised by the brokerage when they had never seen the relevant documentation. The only way to know for sure, besides the consistent testimony of 4 expert witnesses, was to see the documentation, the procedures and manuals. But it seems that the brokerage played a game of hide the ball. It really does seem as if there was something they were trying to hide by avoiding these orders. As the SEC chief, a former SEC branch chief mentioned, there are certainly some kinds of obligations, many kinds of obligations that this brokerage had over the advisor, and yet not one page of documentation was provided. And that appears to me to be a clear violation of Section 682.13 and 682.06, which guarantee the participants in the arbitration the opportunity to present material evidence. In this case, those manuals which they refused to provide were the foundation, the linchpin of the case.
Could you tell me how this was, procedurally, how this developed in the arbitration? You know, they were ordered to produce them. They did not. Then what happened? How is this teed up as an issue?
The hearing took place in August of 2012.
The arbitration hearing.
That's right, Your Honor. And long before that, in February of 2012, the panel already issued an order to compel production of those documents because the FINRA rules required it, and yet it wasn't being done. So all the way back in February, there was an order to compel production, which was ignored. And then in April, there was another order compelling production of the same manuals, which once again was ignored. Now, when I say ignored, they did file something, a notice of alleged compliance, claiming that there were no such manuals. But the experts testified consistently that there had to be such manuals. It was required by the FINRA rules, and they must exist. So after those 2 orders, they still were not produced by the time of the hearing. And the last order in April said that if they weren't produced, then at the beginning of the hearing, they could discuss applying a negative inference, which did not happen. It was discussed, but no inference was applied.
They did not apply the inference.
Correct.
Is there anything in the arbitration rules that provides for the arbitration panel to have an in-camera inspection of the documents and to, if necessary, seal them for further review should an appeal or an order to vacate be taken?
Your Honor, that is a very excellent question, and I'm not really sure whether the rules provide for it, but you're reaching an important point, which is the only way that anyone, including the arbitrators, could have known whether those rules were really relevant is to see them. And that's the thing that they never had the opportunity to do. And therefore, by the combined actions of the brokerage and the arbitrators who failed to enforce the rules and failed to enforce their own orders to compel, they left themselves in the dark, proceeded blindly, and still ruled that there was no obligation to supervise this advisor. That is based on a lack of evidence rather than being based on evidence. And it certainly violates Section 682.13, which makes it mandatory for the circuit court to reverse or to vacate.
At this time, Mr. Snow was not a, what is it called, a Section 7 or Security 7 license holder. He was not a stockbroker, is that correct?
That is right. When he left his former firm, his
Morgan
license
Stanley,
expired.
he moved down to a level of a financial advisor, is that right?
That is correct.
And the name on the door was Private Wealth Management or something along those lines?
I believe so.
And so in order to process, I guess, stocks or certain investment securities, he would have to go through a brokerage, would that be correct?
Yes, there was.
That's the gravamen of the dispute, right?
Right, there was a loophole in the Investment Advisors Act of 1940 that allowed him to execute trades within the Raymond James platform without officially being registered as a Series 7 representative. And there are statements in the contract that he had with Raymond James that say Raymond James had the absolute authority to reject any transaction that someone in his capacity would try to execute. And yet, Raymond James turned a blind eye. The advisor burned through $4 million of this inheritance, while the brokerage turned a blind eye. And it really reminds me of Nero fiddling while Rome burned. And yet, under section 682.13, it was mandatory. There's no discretion. It says the court shall vacate an award when that kind of breach of evidentiary rights occurs. And let me turn to the attorney's fees issue. It is not clear at all that the panel reached any formal decision upon any Chapter 517 claim, which would be for unsuitable recommendations. As we've discussed, the award itself is silent as to Chapter 517, and discussion at the hearing indicates that no one was sure that they would reach any decision on that issue. We take the position that they did not, and therefore Chapter 517 is completely inapplicable. But even if it were to apply, there is no way that $300,000 of fees could be attributed to the hearing, the 5-day hearing, which encompassed all 3 issues. And that issue of Chapter 517 was never raised until 20 minutes before the hearing. The case was filed, I believe, approximately a year before the hearing, and a lot of work was put in by the brokerage attorneys during that time. Now, since the only claims that existed at that time were breach of contract and failure to supervise, it follows that the only claims they could have worked on were those 2 claims. The Chapter 517 claim, according to the brokerage's own attorneys, was not received by them, and they had no opportunity to prepare for it until 20 minutes before the hearing. But in the circuit court, they tried to argue that all of these issues were so inextricably intertwined that they could not be separated for purposes of finding out how much time was really spent on the Chapter 517 claim. That argument is illogical for the obvious reason that they could not have a claim intertwined when it did not exist. There was no 517 claim until the beginning of the hearing. So it did not exist to be intertwined with the other 2 claims. It was impossible. And on the issues of costs, this is probably the easiest issue of all. Case law states that only the arbitration panel can award costs, and it did not do so in this case. But the circuit court did. That is a violation of legal standards and a clear error that must be reversed. Now, regarding discovery, in order to know how much time was spent on the Chapter 517 claim, which was admittedly a brand new claim, it stands to reason that the appellant's attorneys needed information describing what work was done on the various issues. So they requested through an interrogatory a listing of the time spent on that issue. And the answer they got back was, this would be too burdensome and cumulative, it will not be provided. So then their only way to know the information was to depose the attorneys who did the work. And that request also got shut down. So again, they were left to proceed in the dark. They would come to the fees hearing in the circuit court, needing to cross-examine the brokerage's attorneys, and yet they had never had a chance to find out the crucial information, either in writing or through deposition, that they would need to prepare for such a cross-examination.
You have about 5 minutes left.
I'll reserve that for rebuttal.
Okay.
Thank you, Your Honor.
May it please the Court. Your Honor, my name is George Guerra. I represent Raymond James, the appellee in this matter. And I would like to begin by pointing out that there were a number of matters raised by my opposing counsel just now before the Court that were not part of the underlying record, nor do they accurately reflect what happened below. The claims with respect to the amount of money at issue, the amount of losses, etc. But I guess more importantly, what that reflects is that this proceeding and what I believe the appellants are doing in this case is precisely what the case law has instructed is not to be done in matters like this, and that is to undertake the process of resurrecting the underlying case, resurrecting the merits of the case, and attempting to retry the case in a new forum or a new setting. A circuit court's review of an arbitration award is extremely limited, as this court well knows, and confirmation is indeed required absent a showing by the challenging party that the award was procured by one of the specifically enumerated bases that are found in either the federal or the state statute. We contend that the federal statute applies in this case, both as based on the contract that the parties entered into, as well as the fact that it involves interstate commerce. But for the purposes I think that this court is analyzing this matter, I don't know that there's a material difference between the federal and the state statute. And the court's review is also quite limited to a determination that the lower court abused its extremely limited discretion in connection with its review of the award. The appellants have raised several grounds, none of which satisfy their burden in the showing that they needed to make in connection with the review of the arbitration award. The first issue they raised is this notion that the award was, that the panel refused to hear material evidence. And under the statute, that evidence must be pertinent and material, and the denial must result in prejudice such that they were denied a full and fair hearing. That didn't happen in this case for several reasons. First of all, and actually I would like to point out, Your Honors, that even before getting to that point, it is in fact an attempt to revisit the discovery orders by the arbitration panel in this case. And that review is far beyond anything that the trial court would have been allowed to do in this case, and likewise beyond what this court ought to be persuaded to do at this level.
But I have not heard him dispute the discovery orders.
Your Honor, I think that the discovery order that did not require, well, let me clarify, Your Honor, then the order that, as it was represented to the court, and the order as it actually occurred and as the record reflects, the order itself that my opposing counsel referred to indicated or specifically stated that the respondents below were to produce these manuals if and only if they didn't have a valid reason for not producing them. That's what the order says. Pardon me. And so the arbitration panel clearly found that there was a valid reason for not producing them. Again, there were a series of representations made by my opposing counsel concerning what the FINRA rules require, what they referred to as a loophole, which allowed the investment advisor to sell securities, is actually no loophole at all. It's an act of Congress. It's called the 1940 Investment Advisors Act, which specifically allows and provides for the relationship that the investment advisor had with the brokerage firm, that requires that an investment advisor under the 40 Act have a designated custodian, which is what Raymond James was in this case. They also provided clearing services, and under those clearing services, they are executing transactions that the investment advisor, who has been contractually retained by the appellants in this case, is making on their behalf. And when one makes trades on an open securities market, a trade that is not supported by underlying collateral results in the extension of credit. Again, the clearing firm is governed by a series of acts and extensive regulations that require it to maintain the ability to reject a trade and to avoid inadvertently extending credit, as well as for a number of other reasons, including money laundering statutes, etc. But the point is that these representations with respect to what the order required were ones that were presented to the arbitrators, that the arbitrators considered, and that the arbitrators decided. More importantly, though, Your Honors, I'd like to point this out. The consequence of that, what the appellants and the claimants below sought was a negative inference that would allow the panel to conclude that there was a duty that they failed to supervise, that the respondents failed to supervise the investment advisor. That fact was not at issue in the underlying proceeding. The respondents never contended that they did supervise him. The fact of the matter was there was no duty because he was not a registered person, because he was an investment advisor. The FINRA rules, in fact, didn't apply. The record reflects that the appellants tried to both compel and also add the investment advisor to the proceeding. The panel concluded that as a non-registered person, he wasn't subject to the FINRA rules. So, given the fact that the panel considered these issues, concluded that there wasn't a valid basis to require the production of manuals, and that the ultimate impact was completely insignificant, we contend that there's absolutely no grounds to find that A, it's sufficient grounds to overturn the arbitration award, or that the lower court in any way abused its discretion when it drew the same conclusion. The appellants also raise due process issues in connection with their appeal, and they do so without actually specifying perhaps the most critical part of the analysis, and that is the issue of whether or not there is state action, the threshold question in a due process analysis. And the fact of the matter is there is no state action that would support a due process violation. Again, ignoring for a moment that it's not one of the enumerated grounds under either federal or state statute that would provide a proper basis to vacate the award. The sole case that they do rely on for the proposition involves an action brought by the SEC, a governmental agency exercising regulatory authority. That's the Grooms case, and that case is entirely different than this one. Simply put, this was private arbitration by private parties. The arbitrators were not government employees. They did not work for a government agency. They were not exercising regulatory authority or any other state or quasi-state authority. And so the due process argument, we believe, does not pass muster. Let me turn to the issue of the entitlement to attorney's fees and some of the representations or arguments that have been made in relation to the entitlement issue, the presence or the assertion of a 517 claim by the claimants. What I believe is critical and hasn't been addressed is this. Trial counsel for the claimants made the argument in various instances, successfully I would add, that the 517 claim was included in their statement of claim. The record reference to the 20 minutes, I believe I can represent to the court, I believe was 20 days, because at the 20-day mark before the final hearing is when parties exchange witness and exhibit lists. At the 20-day mark is when it became clear that the claimants intended to call 4 experts, 2 of them dealing solely with the 517 issue. The chairman of the panel noted that there was in fact a request for fees by the respondents in their answer, that the statement of claim sought fees as well, but didn't specifically say under 517. In connection with a motion to strike or dismiss their 517 claim, trial counsel for the claimants, again, argued successfully that they were, that their claim was clearly within the statement of claim, that they had referred to violations of state and federal laws, securities regulations, etc., and that that was sufficient. Keeping in mind, Your Honors, that in a FINRA setting, the pleading standard is extraordinarily low, to the point where, or I should say, with the clear intention that anybody can bring a claim. It's not necessarily constructed for lawyers to do it that way, but they're certainly entitled to do it that way. And these lawyers did. And so the chairman concluded, the chairman of the arbitration panel concluded that, in fact, they did include it in their statement of claim. There was a 517 claim. They introduced 2 expert witnesses, one who testified exclusively about Florida Chapter 517, another one who presented damages pursuant to Chapter 517. Ultimately, it was the only basis of damages presented by the claimants at the final hearing. In closing argument, they again argued that the Chapter 517 claim was present and that it should proceed. There's absolutely no reasonable way to conclude from this record that the claimants did not make a Chapter 517 claim. And so that leads to the next question about whether the panel considered it and who was the prevailing party. Clearly the panel considered it because they said they would when they denied the motion to strike the 517 claim. They said specifically, and we cited it in our brief, that they would allow the Chapter 517 claim to go forward. And so on that basis alone, I think that it was clear, and the trial judge was entitled to rely on the fact that it was indeed presented. Excuse me. As to the prevailing party, the case law relied on by appellants isn't controlling, nor is it instructive. Specifically, they contend that because neither the order, because the arbitration award didn't specifically identify the prevailing party, the judge below could not award attorney's fees. That's just a misunderstanding, I believe, of what the cases truly hold. In fact, when a claimant brings a series of claims and is successful on none of them, there's no question, there can be no question that the prevailing party is the respondent. And that's precisely what happened here. That's what happened in the Applebaum case that the 4th District decided. And as a consequence, whether or not it was specified, it's not an issue. It's only an issue when a claimant prevails on some but not all claims and the award is silent as to that. In that case, then, it becomes a question about whether or not the basis upon which they were successful provided an adequate basis or provided a basis for attorney's fees. That's not the issue in this case, nor was it the issue for the court below. And so consequently, we believe Judge Campbell decided it correctly. As a consequence, I would also add, maybe state the obvious, that for that reason, the entitlement to attorney's fees, which under 517 is clear, the court says specifically the court shall award attorney's fees, again, giving the court very little discretion. And so the amount and the reasonableness is also sort of the next logical issue. The court below followed the requirements of Section Florida Rule of Professional Conduct 4-1.5. Her order was quite clear. It addressed all of the issues, and it included also, as part of that assessment, a 6-hour evidentiary hearing. The appellants had the opportunity to call and did call a fee expert. They cross-examined me, trial counsel for the appellees. Court made clear findings on the record. And so based on that record and based on the court's order, there's no reasonable basis to conclude that Judge Campbell abused her discretion in connection with her findings and her determination with respect to the award concerning the reasonableness of the fees. Excuse me.
Could you talk about the question of the discovery issues on the fee question?
Yes, Your Honor. I'd be happy to talk about that because that's, again, an attempt to challenge a discovery order as a basis for overturning an arbitration award. Courts, I dare say, are loath to allow the sort of discovery that the appellants wanted to conduct in the post-merits proceeding, specifically deposing opposing counsel. Courts have recognized that that is a dangerous arena. It allows for delay. It allows for really an opportunity to intimidate the other party, to escalate litigation costs, etc. And so Judge Campbell conducted a hearing, considered all of their evidence, and I think it's important to know and consider what the appellants below did get. My opposing counsel suggested that the only way to have determined whether or not there was some of these fees were tied to Chapter 517, which is a matter I want to address as well, was to depose me. And in fact, they had 67 pages of invoices, detailed invoices with detailed entries, time maintained on 6-minute intervals. Each timekeeper's rate was listed and the amount of time each timekeeper spent on that particular task. They served interrogatories. They were permitted to serve interrogatories, expert interrogatories, requests for admissions, document production, which they made and received. And they were also allowed to depose the appellee's fee expert. And it was limited to 3 hours, which was as a result, again, of a motion considered, we believe, properly by Judge Campbell and ruled upon properly. So in addition to all of that, I would add, there was a hearing. There was a 6-hour evidentiary hearing that, during which trial counsel for the appellees was allowed to question me about all matters and any matters relating to the fees, the bills, my background, etc. And I note that there has been no reference either in the brief or in the record or argument concerning how still, even after that, there could have been any error assigned to the lower court's decision or prejudice demonstrated by that alleged failure. With respect to the amount of, the segregation of the fees.
You're down to about a minute to go, Mr.
Okay,
Garrett.
thank you, Your Honor. I'll finish up real quickly. With respect to the segregation of the fees, I think it's quite clear in the case law that absent a clear ability to do that, or if the cases are part of a common core of facts, which these quite clearly were. In fact, the statement of claims set it up that way by making generalized allegations and then merely making claims under various common law and statutory schemes. The claimants themselves below created a common core of facts, and that's in fact what happened here. That's what Judge Campbell concluded, and based on that, and based on the controlling case law, she clearly ruled correctly and determined that the costs need not be segregated. So for those reasons, Your Honor, we respectfully request that the decision of the lower court confirming the award be affirmed.
Thank you.
Thank you.
May it please the court, I'll see how much of that information I can rebut in the next 5 minutes. First of all, we're not trying to resurrect the merits of the arbitration or the discovery that took place in the arbitration. We're clearly arguing that the failure to consider the evidence is a violation of section 682.13 and .06. And that statute says it is mandatory. The court shall vacate the award when that occurs. And as far as discovery of the fees, it's one thing to be able to serve interrogatories. It's another thing to receive answers to them. And the critical interrogatory here, they refused to answer about how the fees were allocated or segregated between the issues. In spite of receiving many pages of billing records, those records themselves did not clearly distinguish what type of work was done on the various issues. That's why the interrogatory was asked and should have been answered. And in the absence of it being answered, it was necessary to depose the counsel in order to properly prepare for the cross-examination. Yes, he was cross-examined, but without proper preparation because it was denied. Regarding the discretion, I already mentioned, the court has no discretion on whether to vacate an arbitration award when section 682.13 is violated. It is not that the court exercised discretion simply to confirm the award. That's one side of the coin, but the relevant side of the coin is another motion that was filed and was implicitly denied, which was the motion to vacate. And that is where the court does not have discretion. It's mandatory language, the court shall. Was the information in the manuals pertinent and material? It certainly was. It was the key to show that the brokerage had a duty to supervise the advisor. And a negative inference, I don't think it simply was to say that the brokerage did not supervise. They clearly admitted that they did not. I think the negative inference was to infer that they had a duty to supervise and then failed to do so. That negative inference should have been applied. And under that inference, the appellants should have won the arbitration. As far as due process requiring state action, sure, it requires state action, but we're not arguing constitutional due process. That is a red herring. We're arguing statutory due process under section 682.13 and .06. Regardless of the scholarly material and law reviews and some case law that we cited, that said it could be, maybe should be constitutional. That's not our argument. It is statutory. And once again, it's mandatory. Regarding the 20 minutes, here's the source of the confusion. My opposing counsel stated in the circuit court that he had received the information. No, he stated that there was a transcript from the arbitration which stated that he received the information 20 days in advance. But the actual arbitration transcript itself, which is cited in our brief, says 20 minutes. And is that arbitration transcript that must control, that indicates as the original source material that the authentic argument in the arbitration was that they received the 517 claim 20 minutes ahead of the hearing. And therefore, all of that time spent for the months before the hearing, I think almost a year, could not possibly have been spent on the 517 claim or even intertwined with it, because it did not exist.
Time is almost up.
Thank you, Your Honor. In that case, on the remaining points, we will rely and rest upon our briefs. May I simply say that every point raised in this argument and in the answer brief is thoroughly refuted in our briefs. And I pray that the court will give them the greatest consideration. And we know that it's difficult to overturn an arbitration award under Section 682.13. But again, there are cases where it is mandatory and where justice demands it. And if ever there was a case where justice demands it, it is this one. Thank you.
Thank you all. Our next case is Howell versus SunTrust Bank.